We have a guest now in the studio. Justice Thursday's conversation. We have been talking about tribunals. We have had very many tribunals being discussed here. Many. Daisy, have you heard of the tribunals? There's the Energy Tribunal. Of course, you know the Political Parties Dispute Tribunal. You've been applying the political process. There's a Tax Dispute Tribunal. There is the Energy Tribunal. There is the Rent Dispute Tribunal.
Very active one.
Very active one, right? Last week we were having a conversation about what was cooperative. It was the cooperative. It was cooperative tribunal. Yes, members of cooperatives and wondering what they were. So we have one other tribunal. We'll introduce the guest shortly after he hears the day's proverb from CT.
Isn't it wonderful when your guest knows more about what you've been discussing than you do?
Yeah, it shows that he's been listening. It's a very good thing.
But, you know, we have a disclaimer.
Yeah.
When do people get time to watch the show? Because us, we never watch this show.
Buona.
Yes, surely. We must make time to watch this show, shouldn't we?
Okay.
Okay. We are in the land of the pharaohs. We're in Egypt. Every man is rich in excuses to safeguard his prejudices and instincts.
Every man is rich
in excuses to safeguard his prejudices and his instincts.
Dr. Jackson Bett is the chairperson of the Micro and Small Enterprises Tribunal. This is the Hustler Tribunal. I'm sure he's going to tell us that. Dr. good morning.
Good morning.
Thank you very much for joining us and sitting on the hot seat of the Situation Room. That proverb, do you relate?
Yes, I think I would relate to that program. And it reminds me of the quote by Anthony Robbins, that you would always find an excuse to, hang your excuses on. But ultimately, they remain as excuses. You can't move an inch because they are just excuses.
They're just excuses.
Yes. So
They're
that
not
is
reasons.
that is my perception of that quote by CT.
I think it makes a lot of sense. Dr. what is this MSME's tribunal?
Thank you very much, Eric. So the Micro and Small Enterprises Tribunal is a tribunal that has been established under the provisions of the Micro and Small Enterprises Act, number 55 of 2012. The essence of establishment of that tribunal is really to resolve disputes within the micro and small enterprises.
Who are micro and small enterprises? The other day we had a boss from KRA and he was telling us, small businesses have a turnover of about 700 million shillings.
Yes.
And we're like,
What are the
Small.
parameters?
Yeah.
What are the parameters?
What
Because
is
of-
micro and what is small?
Yeah.
Yes. Indeed, the perception that has been created over time is that micro and small enterprises are minute organizations. I think I'm here today to demystify that notion, because the micro and small enterprises really are not as micro as we might want to imagine. And the reason why I'm saying this is because the definitive aspects of the micro and small enterprises, let's look at the micro enterprises in the first instance. These are, it's a trade, it could be a farm, it could be a business entity, it could be an industry. But then in terms of the annual turnover of a micro enterprise, it goes up to 500,000 shillings. Now, when you look at the asset portfolio of the micro enterprises, it depends. So that if you're looking at a manufacturing micro enterprise, its asset portfolio could span up to 10 million shillings. And if it is within the agricultural or farming sector, the enterprise or the financial asset portfolio could run up to 10 million shillings. Actually could run up to 5 million shillings. So that is the parity. Now, when you're dealing with the small enterprise, of course, these are elevated versions of the micro enterprises. And the annual turnover of a small enterprise could go up to 5 million shillings. Now, in terms of the numbers of the labor force of a small enterprise, it is between 10 persons to 50 persons. Now, the asset portfolio of a small enterprise, depending, if you're looking at a manufacturing small enterprise, it is between 10 million shillings and 50 million shillings. And if it is within the farming or agricultural sector, it is between 5 million shillings and 20 million shillings. City, I think you'll agree with me that even though we look at these enterprises as really, really small units, the asset portfolio of those enterprises could actually run to billions of shillings in the long run. Yes.
That's actually a very big organization, one that employs about up to 50 people, 5 million shillings annual turnover. Yes. Then the asset base, if you talk about in manufacturing, up to 50 million shillings in assets.
Yes.
That's a big enterprise.
Yes.
Okay.
And just to also elaborate more on that, the conglomerates of these micro and small enterprises are referred to as associations. And of course, there is a regime that is now available for purposes of registration. One association has at least 35 micro and small enterprises.
Oh, like now, the Juakali Association.
Precisely.
Okay.
Now, cumulatively, if you are to look at 35 entities with an asset base of about 50 million shillings,
million each,
it actually tells you that one association could have an asset base of about 1.75 billion shillings. That's huge.
If not more. But
if not more.
I have to ask this, Dr.
Yes.
How do you arrive at this classification? Well, small, medium, not so medium, not so small. I mean, how? Yes.
Minute,
microscopic. I mean, how do you arrive at this?
Well, these are the definitive provisions under the Micro Enterprises Act. And I think the idea was to ensure that however small an entity is, because when you're dealing with a micro unit, you can see that the asset base is up to 5 million shillings. The number of persons is up to 10 persons. So it means it could be from 1 to 10 persons. The annual turnover could be between 1 and 500,000 shillings. So that is what defines.
So a border operator is in the same category as a company that has a 5 million turnover.
Well, if you are to look at it from the definitive aspects of a micro enterprise under the Act, I think it would fall within that category.
So it's that border, it's Mamamboga, also farmer.
Yes.
Because the majority of farmers, and if you look at this asset base of 5 million shillings in agriculture sector, employing up to 10 people, annual turnover of 500,000, many of farmers would be in that category.
Yes.
Somebody with a cow and they're selling milk and selling milk to
an aggregator.
So those are all categorized as businesses and they're recognized in law.
Well, they are recognized.
Or do they have to be
informally.
registered?
They are recognized informally as such. But when you look at the provisions of the Micro and Small Enterprises Act, there is a requirement that these micro units should be registered.
Okay.
Yes. The fact that they have not been registered, though, doesn't mean that they are not recognized as such. Yes.
Maritime Minor Daisy Farm. And then you categorize that you fall into this. So what kind of disputes would emerge in this? And what do you deal with?
Yes. Now, the reason why the Micro and Small Enterprises Tribunal was formed was in order to deal with all the disputes within the industry. And there are three parties that could be isolated within that framework. We have disputes between the members of the micro and small enterprises amongst themselves. We have disputes between the members of the micro enterprises vis-a-vis the association. We have disputes that may exist between the members of the micro and small enterprises vis-a-vis the authority, because there is an authority that has been established. That is the Micro and Small Enterprises Authority that registers these micro and units and associations. So that is the first limb in terms of the placement of the parties. But in terms of the specific disputes that may arise within the industry, the first category of disputes are commercial disputes, which may arise. It could be a debt, that a member has been lent some money by the association, or one of the micro entities has been lent money by an association. So then of course they fail to pay. That's a dispute that can be classified within the commercial framework. We also have other disputes which are not commercial in nature, and these disputes include, for instance, where an enterprise fails to adhere to the rules and regulations governing the institution. We could also have disputes relating to misallocation.
An enterprise fails to adhere to rules governing the institution.
Yes.
I'm lost.
What that means is that every association, for instance, that has been formed, it would have rules and regulations.
Okay.
It could have a memorandum of understanding, but it could also have a constitution that govern that entity. So if there is any transgression insofar as the adherence to those rules, then those disputes can be presented before the tribunal. Yes. Now, in addition to that, we have disputes relating to leadership and elections of the members and leaders of the association. Now, in addition to that, we have disputes relating to allocation of work site, disputes relating to irregular, distribution of work sites, and in this particular case, what comes into mind would be it could be Juakali artisans, it could be hawkers, in a government
market.
Yeah, so such disputes would be presented before the tribunal. So you can see that we deal with both commercial related kind of disputes, but we also deal with disputes of a nature that are not commercial. Yes.
Are there within the tribunal, or maybe within the act, because I haven't had an opportunity to peruse it, are there sensitivities or some affirmative consideration towards women operating MSMEs?
Now, gender perspectives would always be considered, and that explains the reason why, as a tribunal, we always try as much as possible to ensure that the rules and regulations that govern the institutions are adhered to, so that if there is a framework that has been created within a micro and small enterprise or an association and is not gender sensitive or gender friendly, then our work as a tribunal is to point out that indeed there has been a transgression, and of course urge the members to consider ensuring that the same has been
and
realized.
Yes. And seeing it through that lens, that there are particular and sets of challenges that are very particular to women.
Yes.
For example?
Harassment.
So within the association, let's say it's an association of hawkers, okay?
Yes.
So there would be, so internally among the membership, maybe that harassment and discrimination based on gender?
Because I know, or you've mentioned, and I hope I got it right, that there's also the regulators, for instance. What do you call it? Now, people who enforce the law.
Like Kanjo
Now, if it's,
Askaris.
exactly. Yeah. So now there's an association of hawkers, and I don't know if it's an association of women hawkers or whatnot. And they face different challenges when it comes to their interaction and engagement with the law or with law enforcers or with Kanjo, people who regulate their licensing and that kind of thing. And one of the challenges that stands out particularly for women is harassment, sexual harassment, or, just the societal standing of women depending on where you are in the country. Those kind of considerations.
Exactly. Do you deal with those?
Now, I think we need to distinguish the jurisdiction of the Micro and Small Enterprises Tribunal from the jurisdiction of other entities within, the realm of access to justice. And in this particular case, the High Court and the mainstream, magistrate courts. I think it has to be very clear that the tribunal do not deal with enforcement of rights and fundamental freedoms as provided for in our Constitution. That is a matter that, is dealt with at the High Court. The tribunal only deals with the business-related disputes within the micro and small enterprises, the associations, and the authority. Now, let me just clear this, that the only area that the Micro and Small Enterprise Tribunal addresses in terms of administrative overreach would be in situations where the micro and small enterprise wishes, to be registered, and the registrar, for whatever reason, without, giving reasons, fails to register the association or a micro enterprise. Secondly, in situations where there has been an arbitral cancellation of or suspension of registration of an association, then in that particular case, the aggrieved parties would have the right to approach the tribunal so as to ensure that that particular administrative overreach is redressed or corrected. Yes.
What's your caseload?
Now, the caseload at the moment is not as heavy as you would expect, and primarily, I think, because the institution is relatively new. We have about 20 cases at the moment. For the period that the current tribunal has been in office, we've dealt with slightly over 100 cases. And of course, the kind of cases that we've dealt with are vast. We've dealt with cases in different parts of this country. We've dealt with a case involving about 1,500 border operators in Kericho. We've dealt with a case involving about 1,000 members of the Nakuru Shabab Juakali Association. We've dealt with a case here in Nairobi involving the Kamukunji Juakali Association that has a membership of about 5,000 members. And we've also dealt with a matter in Mombasa involving hawkers and Juakali artisans with a membership of about 5,000 strong. So to that extent, therefore, you can see that even though we've not really dealt with very many cases, the outreach in terms of numbers, I believe, is huge, because Kamukunji Juakali Association, for instance, with 5,000 strong members, I believe when you look at the numbers, really, those are very many persons. And if
was it a dispute between the association and somebody else, or was it a dispute within the association?
It was actually a dispute within the association. It was about allegations of misappropriation and misallocation of funds. There were also allegations relating to leadership, because there were two factions that claimed leadership. But to cut the long story short, Eric, I must say that the tribunal was able to resolve that matter within a period of 60 days. And that would really be considered as one of the highlights of the achievements of this particular tribunal.
100 cases, you say?
Yes.
Okay, now, do you see any emerging pattern? Do you see any emerging concurrence of issues, something that you see it and it recurs again,
Yes.
and you see it again, and so there's a commonality, there's a thread that runs through this?
Yes.
Have you encountered such a phenomenon?
Yes, we've encountered such a challenge, and what comes out very, very prominently, City, is cases relating to mismanagement, misallocation of funds, issues relating to leadership wrangles. Those are the fundamental issues that have arisen over
the
past.
typical issues.
What unakula pesa?
What I see with the work that you're doing, Dr. Bett, is really about perhaps access to justice to some groups of people who would otherwise have had difficulty getting redress. For example, the boda, you said how many in Kericho? 100?
1,000.
1,500
Yes.
500 boda operators in an association. In the absence of the tribunal, what would have the process have been?
Aye,
And how different would it have looked like?
it would be a nightmare.
Yeah.
You just think of it going through the normal
Yes.
judicial process.
Absolutely.
That thing would get jam-locked even before it moved.
Absolutely, and I'm seeing there's a focus on your end about the timelines within which the cases should be concluded. Is that right?
Yes, actually, Daisy, let me state this, that the tribunal as it exists has distinguished itself in the sense that we want to render justice to a particular distinct group of persons who would have had numerous challenges if their issues were to be convoluted with the other cases. And we try as much as possible to ensure expeditious disposal of disputes within 60 days.
Yeah.
Actually, with our service charter provides for 90 days, but we try as much as possible to resolve those issues. Actually, 95% of the cases that we've dealt with have been resolved within 60 days. And you can see that I'm making emphasis on resolution of the dispute, not just determination of the dispute, because you can't determine a dispute. You can say that this side has won, the other side has lost, but that is not the idea. The idea is to resolve the dispute so as to achieve both justice and peace at the same time. And to that extent, therefore, we see the small and micro enterprises, the micro and small enterprises tribunal, as a very, very important institutional framework in ensuring societal transformation and ensuring societal stability at that basic level. Because if you are to look at the micro and small enterprises as the most basic tools of production, and the reason why I'm saying this is because a micro enterprise is that trade, it is that industry, it is that service, it is that a business entity. Yeah. So if you are to look at it from that standpoint, you find that it is a basic unit that can cause, economic growth and the development. And of course, most importantly, to improve the livelihoods of,
Yeah.
of the citizenry in this country.
Indeed. 27 minutes to 10. Let's take a quick break. Dr. Jackson Bett is the chairperson of the Micro and Small Enterprises Tribunal. We're talking about the role of this tribunal in Chief Justice Martha Koome's strategy of social transformation through access to justice. What is it that they're doing? And we've heard that, yes, they're dealing with very many small and micro and small enterprises forming into associations. So we're talking about very many people who are benefiting. These are the same people, by the way, who are also being targeted by the Kenya Mortgage Refinance Company. Any individual or group that is earning up to 150,000 shillings a month can actually go and seek home ownership through KMRC at less than 10% interest for as long as 25 years. See now how they all come in. Imagine if all this information was available to everybody at all the time and access is easy, how that would be able to move. You guys are in a circle, you're thinking about how much you're earning. Can you talk about home ownership? There's affordable housing that's being rolled out on one side. There's money being available on this other side. There's mortgage refinancing happening on this side. And if there are disputes, there's dispute resolution happening from this front. This and more conversations coming up shortly.
This is the Situation Room, the only way to start your day.
Dr. Jackson Bett is still here with us in the studio. We're talking about the work of the Micro and Small Enterprises Tribunal. With now the opening up of the space on access to justice, so we've got tribunals, we've got the formal court systems, and then we've got the alternative dispute resolution mechanisms, the alternative justice system that's also been rolled out by the CJ. Now, if you look at members of a particular, say, association like Nakuru now has an AJS that's been established, the alternative justice system mechanism.
Yes.
And then you have the tribunal such as yours that's present. How do you let your members know when to come to you, when to go to AJS, when to go to court?
Thank you very much for that question, Eric. Now, what happens is that the disputes that come to the tribunal should be considered as, tribunal should be looked at the lender of the last resort within that matrix, in the sense that if the members of the association are not able to resolve their disputes internally, if they are not able to deploy, ADR mechanisms amongst themselves, and it so happens that there is no other way out, then it is then that they approach the tribunal. So, and a number of times, even before we hear the parties, we ask the parties whether they have deployed the internal dispute resolution mechanisms. So to that extent, therefore, I think you can clearly see that there is a web in terms of frameworks for resolution of disputes. And of course, it would not be advisable for the members of the association to jump the gun to come to the tribunal before extinguishing the internal mechanisms. Now, now that we have the alternative justice kind of systems, well, it is a feature that should be encouraged, because when you look at our Constitution, Article 159, it provides that alternative dispute resolution mechanisms should be encouraged and promoted. And this would include arbitration, we have reconciliation, we have mediation, and we have traditional dispute resolution mechanisms. And of course, there is now an extended version of the same, that is the alternative justice systems. I must say that as members of the tribunal, we, some of us are trained. I'm a trained mediator, certified mediator. My vice chair and another member is also mediators, and therefore we are able to deploy these mechanisms when we deem that it would be the best way to address the pre-existing dispute.
Which is the cheapest way to get a dispute resolved? Look at your member. Look at the people who've come to you. I mean,
Yes.
Juakali, artisans, border riders,
Yes.
people operating in the market. What's the cheapest and fastest route of getting a dispute resolved? Like you said, it's not just judgment delivered, but resolution.
Now, to answer that question, I think you need to look at the entire spectrum of the dispute resolution frameworks. I've indicated that we have mediation, we have reconciliation, we have arbitration. Then, of course, we have the mainstream adjudication process through the court process. It could also be within the tribunal framework. But in my view, I think mediation stands out. The reason why I'm saying that mediation would stand out is because you're giving the parties an opportunity to resolve their disputes themselves. You're giving them a chance. You're just providing a platform for them to understand their disputes well and to think of mechanisms to resolve their disputes among themselves. So for me, I think mediation really stands out. And with mediation, you're able to achieve peace and you're able to achieve justice at the same time. So I think that is what I can say about that pre-existing framework. And as it is right now, we have court-annexed mediation, which really provides a framework for deployment of mediation as a dispute resolution mechanism. Yes.
This question I asked about this common thread.
Yes.
Did you answer it? And when you did, was I in the room?
Was that today?
Yes, indeed. Well, as I stated, the common thread disputes of relating to mismanagement, misallocation of funds, and leadership wrangles. Those are the main disputes, and I think history and experience have taught us that you may not really deploy the traditional adjudication processes, to resolve those kind of disputes. There has to be a clear understanding between these the warring groups. What we've done in the past is to inform, or rather to encourage the warring factions that let the bygones be bygones. Let's begin from this point moving forward. What is it that ought to have been done right in the past? Could we provide a conducive environment where elections can be conducted afresh, and you bring in the correct oversight mechanisms to ensure that the process is transparent, free, fair, credible, and so on and so forth. And we've established that has actually provided a breakthrough, because we give an order to that effect that the election would be conducted on this particular day. It would be superintended by this entity, and that a part of the team that would be organizing the election would even involve, the registrar of the micro and small enterprises, and of course, including the CEDO, that is the County Enterprises Development organizations. So to that extent, therefore, we found a very conducive way of dealing with those kind of disputes.
I keep thinking that the work you're doing really contributes to overturning this notion that justice is for the rich and the law is for the poor. What I want to ask, I think based on what you're describing, there needs to be such a high level of specialization in terms of how your tribunal is constituted, because your work is a combination of the law and business.
Yes.
So what do the people who sit in the tribunal look like?
Okay. Thank you very much, Daisy. Now, the tribunal, as established, has diverse membership. The chairperson and the vice chairperson are nominated by the Judicial Service Commission and appointed by the Cabinet Secretary. The qualifications of the chairperson and the vice chairperson are that of a judge of the High Court. So those are the two members. Cumulatively, we have seven members. Yes, so those are lawyers. Secondly, we have a member nominated by the Law Society of Kenya with 7 years experience as an advocate. Then we have two members who are lawyers with expertise on micro and small enterprises laws. Then we have two members who are non-lawyers but have expertise and experience in the management of the micro and small enterprises. And of course, those ones are appointed by the Cabinet Secretary in consultation with the authority, that is the Micro and Small Enterprises Authority. So you can see that with that combination, the membership is diverse and versatile and is able to deal with issues without really considering the legal lens in exclusion. Because a number of times we seek, to find out from the representatives of the experts of the micro and small enterprises. And when they give their perspectives, then we realize that if we were to look at it from the legal lens exclusively, we would have missed the point.
Yes.
So I think I would say that is one of the advantages.
The advantages, because you're bringing in the voice.
Yes.
But then explain to me, then, why do we need so many lawyers in a tribunal? I mean, surely the whole essence here is to resolve disputes.
Yes.
Why must we have lawyers? 2 lawyers of the High Court, 2 lawyers, a lawyer nominated by LSK, somebody who gets endorsed by LS. Why must we have so many lawyers?
I think the reason why that is the case is because at the end of the day, this is a quasi-judicial function. Yes. So, and a number of times you'll find that we pronounce judgments, we give awards, we sign decrees, and our powers are derived, from Article 159 of the Constitution, which is part of the judicial function, as delegated, under Article 1 of the Constitution. So to that extent, therefore, you can see that we cannot really lose sight of the judicial aspect of this the dispute resolution process. But let me also state that the reason why lawyers would form a critical core of the membership is because in the first instance the chairperson has to chair the tribunal. The quorum is 3. Now, in the absence of the chairperson, the vice chairperson can preside over the tribunal. So that therefore means that the chair and the vice chair ought to be lawyers.
Okay.
Yeah,
so you can have 2 panels at the same time.
But in the absence of the chair and the vice?
In the absence of the chair and the vice, then there's no business that can be transacted.
There's no quorum.
There's a bit of a problem there, isn't there?
The leadership of the quorum must have chair or vice.
Yes. That is what the Act provides.
Well, it makes sense as well.
Yes.
Where do you get your money from?
Now,
Are you getting it from Moses Kuria's ministry? Or are you getting it from the Judiciary Fund? Getting it from the Treasury?
Public Service Commission?
now we are being funded by the judiciary. Yes, and I think I would dare say almost exclusively, by the judiciary.
I have to ask this question, Dr.
Yes.
You work with this organization, these people. How are they represented in this tribunal? The membership, are they people who are, say, chair of SACCO? Meaning, yes, because you are arbitrating, you are overseeing disputes that these people have.
Yes.
The people who are the originators of these disputes, are they also represented? Are they in the tribunal? Do you have somebody?
You're saying beyond the 2 members who are nominated by the cabinet secretary?
Now,
Yes, yes, because that is nominated by the.
So you want like people who are elected through some federation?
Yes,
of
meaning the yes, there's consensus in that this is the person we feel ought to represent us in this tribunal because we understand that they would understand our issues. So when this tribunal is doing their business, because the lawyers understand the law, but do they understand these enterprises that we're speaking
And
of?
that's exactly it. That's what he was talking about, the diversity of how it is constituted. Yeah, so that
I'm
it's
actually
a
saying 2 is
nexus.
not enough. That's really what I'm saying.
okay. I think that is an issue that could be looked at, for future reforms. And the reason why I'm saying this is because the current structure is that we have 2 members appointed by the cabinet secretary, but with expertise in the management of micro and small enterprises. But then that is done in consultation with the authority. My assumption here is that the authority is endowed with the capacity to determine experts within the industry, because it is the one that registers the associations.
Dr. I actually want to differ with Dr. on this point.
It sounds those are technocrats.
Yes, exactly. I think, you see, it's a gentle disagreement. Very gentle in this sense. These are not experts in the functions of this business. They are experts in the structure, in the finances. The day-to-day management of any such enterprises, the experts are the people who do it on a daily basis. They are the ones who actually know. Forget the other people who oversee and do all these things, who regulate. Okay, like for instance, what is your area of expertise?
Lawyer.
Well,
As a chairman.
No. I'm going somewhere with this. Lawyer?
Yes, but
Exactly. Now, you see, by the time you get to the level of you have a PhD, you've specialized or you've specialized in a specialization.
Yes.
So you understand that.
Yes.
But the reason why you are called an expert is because you have gone and done research. And the research usually has to do with cases that involve, it's not just what is written, but the entire accumulation of knowledge that arises from case law and all these things.
Yes.
Okay. Now that's what helps you provide, gives you the expertise. Now I'm saying, here you have a situation where you don't have to read. The people actually live there. You see them. These are the people who work on a daily basis in this. Why are they not represented?
Okay.
Yes.
Okay. Yeah.
And cabinet secretary appointing them. That one, forget. That doesn't cut it.
Cronism.
Yes, that doesn't cut it. That isn't representation. That's ring fencing safety. If I'm the CS, I'll elect people who I know won't give me problems.
What would this person look like, City? Would it be a retired businesswoman, for instance?
No.
Because a practicing
association
business
chairman.
person would not, perhaps sit in a tribunal and engage that much time solving 100 cases in I don't know how long.
Daisy, this top-down approach that Dr. is talking about works up to a certain point. If you want what you call buy-in, the very people whose business you're overseeing need to feel that somebody whom they have determined, is there. Yeah. Then they feel we are represented.
I agree with you,
That's true.
City, that that is an area that would merit reform in the future, so that there is clarity in terms of the 2 persons who represent the business enterprises. Yes, but I think the diversity, as it were, at the moment, really has helped us in looking at dispute resolution from different perspectives, from the social perspective, from the economic perspective, and also within the legal perspective. And I must say that in terms of societal transformation, we can say in affirmative that the Micro and Small Enterprises Tribunal is a game changer in ensuring that the blueprint that has been devised by the Honorable Chief Justice is realized. And we do that by ensuring expeditious disposal of disputes at low cost, and ensuring that we go to the substance of dispute resolution without really
sideshows and delays and
But this stuff is commendable.
Adjournments.
When you look at what the Chief Justice and the team who work with her have done with these issues, if you're talking about bringing justice machinani,
this
Yeah.
is it.
and I mean this is it really.
This is it.
Yeah.
Yes.
Dr. Bett.
And also allow me to say that in terms of access, you don't have to come to Nairobi to file a dispute with the Micro and Small Enterprises Tribunal. You can go to the immediate registry. If you're in Kitale, just go to Kitale registry. If you're in Busia, you go to Busia registry. All that information would be relayed to us, and we will be able to reach you wherever you are. We move as a tribunal. We don't wait for you to come for us.
Dr. Jackson Bett, thank you very much for joining us. Dr. Bett is the chairperson of Micro and Small Enterprises Tribunal. Our time is up, just like that, imagine. Daisy,
Yes.
thank you very much for joining us.
Thank you for having me.
Did you have fun?
I had a lot of fun. It was
Okay.
such a pleasure.
Okay.
Thank you very
Asante.
much, City, Eric, and Daisy. Thank you very much.
Thank
See you again tomorrow, people.